Hi, everybody, and welcome to Raw Law. This is attorney Arkady Frekhtman. I'm a New York City personal injury trial attorney, and welcome to Raw Law. So this is the show where we can answer your questions. So if you have a question, you can join us live. You could just drop the question in the chat, and then we will answer your questions and we'll interact with you, and you'll have a consultation from a personal injury trial attorney that specializes in the type of case that you may have or that a loved one may have. So we're happy to help. We're happy to help. That's what it's all about. Our goal is helping serious injury victims and families, and we're here to help. And in fact, today it was interesting because I ended up shooting a few videos, and one of the videos that I shot was about the dram shop law. So the way the dram shop law works in New York is that, if an establishment like a bar or a club serves someone like a patron, and that person is already visibly intoxicated, like they're slurring their speech, they're not steady on their feet, there's signs of visible intoxication, and they continue to serve that person, and then that person goes out and he causes, let's say, a car crash, like a drunk driver, and injures someone, then that person that he injures can then sue not only the person, the drunk driver, and the auto insurance, but also the insurance for the establishment, like the bar or the club, the establishment that serves alcohol. So there was a continuing legal education all about dram shop. So I listened to it. And so I'll do another video where I talk all about it. But today I recorded one just about one aspect of it that I thought was really, really like crazy and absurd, the way the law is, at least in New York, where, you're allowed to sue for one thing that you wouldn't even think logically you would be allowed to sue and recover money for, but then another issue where you should be able to recover because it's such a horrific thing and you cannot recover, at least under the state of law as it is now. So it's just one of those like crazy law type issues. So maybe me making a video about it, if people watch it, if people share it, maybe we could change the law, because the law is just unfair and absurd. Okay, but let's see what questions we have. Come along with Uncle Joe is here. He says, good evening. Oh yes, good evening. Thank you for being here. Let me put it into live chat so I see all the messages. Marquita is here. She says, hi, thank you for the lawyer suggestion. You texted me yesterday. You're amazing. Oh, yes, absolutely. Yeah, actually, that's a good lawyer. Yeah, reach out to him. Maybe he could help, because I remember Marquita has that case, right? But you're not really happy with your lawyer. There's no movement. The lawyer's not even filing a lawsuit, which is the first step, right? Filing a lawsuit is like, day one kind of stuff. Like you meet the client, you shake hands, you take an intake. Hey, what's your name? What happened? And then, once you have their medical treatment, once you understand what their injuries are, you file a lawsuit. That's what lawyers do. And then the case starts, right? That's like day one. But if the lawyer's not even willing to do that, wait a minute, what are you doing? You're just holding on to a bunch of papers? You're sitting in your office and you're holding on to paper. That's not going to do anything. That's not going to accomplish anything. Okay, and then Moha says, hi, thanks, Arkady, for the great info. Oh, you're very welcome. And Gaytree says, hello, Mr. Arkady. How are you? I wish you can share yourself in different states. You're an excellent attorney. Yeah, no, absolutely. I try. I mean, I do my best. I do help people in different states. Usually what I do is I partner with other people in other states. But for example, with like Gaytree's case, I think you have a case in Florida, right? So you have an excellent attorney that you're working with. And then if that attorney needs my help, if the case does go to trial before a jury, I'll come down. I'll come down to the nice sunny weather and I'll do the trial with them. Absolutely. I love to partner with people. And then Sarah says, hi, I don't reside in New York, but I'm currently pursuing an ice slip and fall case. I don't know if you would be able to answer my questions, but if they are not liable for the ice, there was also poor lighting on the premises. How likely for them to be liable? I was an invitee to the property. Yeah, so I mean, like what I always say is, clients like yourself, don't worry about all these things like invitee. That's like more legal mumbo jumbo. Just, focus on what happened, right? You could text me 347-566-9595. Just tell me the story of what happened. And then what I'll do is I'll ask you questions. We can have a free confidential consultation. And then, I could give you some wisdom. And I think, look, if you went to somebody's property, you obviously were not a trespasser, right? You're an invitee, they invited you. So you had the right to be there. If there was ice, it depends on like when it stopped snowing. If it stopped snowing a long time ago, like 2-3 days ago, right? There was no precipitation, nothing falling from the sky. They had time. They could have cleaned the ice, and they chose not to clean the ice. And then look, you go there, and the ice is like in a walkway where you can't avoid walking. They're liable. And then look, if they didn't have lights, that's another issue, right? Because if you don't have lights, you can't see, and then you could fall. So that's another claim. That's a separate issue. But yeah, it sounds like it could be a case. But I would focus on like, what happened. If you text me, just tell me what happened, 2 or 3 sentences that would allow me to picture it. Like I watched it on a screen, on a movie or whatever. And then I could give you other questions, and we could meet, talk on the phone. And then maybe I can help you if you need help. If you need an attorney in your state, I'm happy to help. Whatever you need, I'm happy to help in whatever way I can. But I've done a lot of slip and fall cases on ice, and in general, I think most of them I've won. A lot of the time you can win those cases. The only time when it's really, really hard, where you might have to settle or you would lose, is like if there's what's known as a storm in progress, meaning like if the storm is going on, like it's snowing now, and then they don't have a duty to clean, right? Because if they clean, well, guess what? More snow is going to fall. So what's the point of cleaning? So that's different. That's hard. But as long as it wasn't a storm in progress, if there's ice on the ground, you can usually win those cases. And then Moha says, is the lawyer allowed to record your conversation without your consent? Do you mean like your lawyer or the other lawyer? I mean, the other lawyer, I don't think so. They probably would tell you, like the insurance company, when they call you and do those recorded calls, they usually say, hey, this call is being recorded. I don't think they can do it without your consent, but it depends on the state. In general, like, your lawyer really wouldn't be recording unless they're just like using it. Some lawyers use it like to take notes, kind of like the same way a lawyer would be taking notes on a legal pad, but they just like they have apps now that like transcribe some calls. So the lawyer could be more relaxed and, speak with you and focus on you. And then they have their notes being taken care of by like one of those apps. But yeah, there are some one party consent states where if one party consents, like for example, if there's 2 parties to a call, but only one party consents, that's all you need. So I think New York is like that, but it depends. You have to research that. Every state has their own laws on that. And then Benito says, best lawyer, definitely recommend 100%. Oh, thank you so much. I really appreciate that. And Preacher says, man, why do I have to tell my lawyer how much is my case worth and how much I want in my pocket to settle? Yeah, well, actually, that's a good point. I did a video about that. I think it's kind of silly, because look, the lawyer should know what cases are worth and what, they can get. And, the lawyer really should, the lawyer can't say, look, this is worth, 50,000 and that's it, right? The lawyer has to maybe get your input, what you think, what you're looking for, sure. But the lawyer should know value. The lawyer shouldn't be asking you value because you, as a client, you would have no idea, right? Clients sometimes might think a case is worth like 50,000, and in reality, that case is really worth maybe 500,000 or more, right? Because there's a lot of damages that a client may not even know about. Like, for example, I did a settlement letter this week, and it ended up being that I'm going to put a high amount in the letter. And I was even thinking, should I put this amount? Because the amount I'm going to put is many millions, and it's almost like the entire, in fact, it is the entire insurance policy. So I was thinking, look, should I really put this? If I put the whole insurance policy, they're not going to they might not pay it. They might say, oh, that's the worst we could ever have to pay. So, we'll give you $1 or whatever. And just, really lowball me. But look, then I thought about it, and there's all these different elements. There's, of course, pain and suffering, past and future. There's like brain injury type issues, post-traumatic stress disorder type issues. There's actual surgeries and physical injuries. But then there's also like lost wages or something known as like unrealized occupation. Like if you're studying to be a certain profession and then you can't realize that profession, you can, you lose money. And then if that gets delayed like 2 years, 3 years, well, all those salaries, like if it's 100,000 a year for 3 years, that's 300,000. So it all adds up. And then future medical costs, the cost of surgery, the cost of prescriptions, the cost of physical therapy, just that could be into the millions. So it all adds up. But yeah, I don't think you should be the one telling your lawyer. I think your lawyer should have an idea of what they can get and what a case is worth based on all of the facts and circumstances, right? Like how much insurance is there, what are the injuries, all of that. The lawyer should be guiding you. You shouldn't really be telling the lawyer, right? Just like a doctor, if the doctor has to do surgery, they know how to do the surgery. They're not going to say like, where should I cut? Should I cut here or should I cut here? Like, what kind of incision do you want? The doctor should know what kind of incisions are proper. So that's kind of silly, yeah. And then Marquita says, should I just continue gathering bills and records in the meantime? Yeah, you can, but give that lawyer a call. Speak to him, see if he can help. If you want, I can reach out to him and have him call you if you don't mind, whatever you prefer. And then SCB says, hi, Arkady, super lawyer. Thank you for all your insights and wisdom. Helps so very much. Oh, you're very welcome. Yeah, I'm glad that it's helpful. Like I love to help, and that's what it's all about, And then Alex says, what is a compliance conference and why is it a year after the preliminary conference? Does that mean my case can take that long in Brooklyn? Yeah, so basically what they do is the preliminary conference is the very first meeting, right? So what they do there is they give you, kind of like a plan or a blueprint for the case. So they say like discovery is to be exchanged, like documents. You give them medical records, right? Because you're suing. They give you whatever you want from them. Like if it's a car crash, they'll give you property damage estimates, photos of the cars. If it's a slip and fall, they might give you maintenance records or photos of the whatever it is, right? The ice or the condition of the ceiling or the collapse, whatever documents or photos you want. And then also depositions, like they get to question you as a plaintiff, and then you get to question them. Your attorney gets to question the people you're suing, as well as any like non-parties, maybe former employees or witnesses or non-parties that are affiliated. So anyway, so as you are going through all this, what the compliance conference does is it just makes sure that whatever was in the preliminary conference order, all of the documents, all of the depositions, was actually done, actually complied with. That's why it's called a compliance conference. Like if you were supposed to take, let's say, 5 depositions and you took 3, well, guess what? Like, thank you for getting the 3 done, but here's more time to get the other 2. And then once everything is done, you certify it as trial ready and you file a note of issue. That's how it works. So it just depends on the court. Like sometimes they'll give you a compliance conference 6 months out. Sometimes they'll give you, I guess, a year out because they gave you a year to get everything done. So I guess maybe it's a complicated case that it takes that long, or the court is just slow. It's hard to say, but probably. So yeah, if everything gets done, then you get a certification conference. The case gets certified as trial ready. And then at that point, you have your pretrial conferences, settlement conferences, possible mediations. And then if that doesn't settle, if nothing can be done, then you have the actual trial date. So that compliance conference, even though it's a year in the future, that's not anything, right? It's just to make sure you complied with your discovery obligations, the exchange of documents and depositions. But then it could be another year from there until you get a trial, because depending where you are, like Brooklyn, Manhattan, about a year wait. Bronx is actually 2-3 years wait. Queens about a year. Staten Island, Westchester might be a little less, like 9 months. Just depends on where you are. And then Sarah says, thank you. I will be texting you. Could you repeat your number again? Oh, sure. It's 347-566-9595. Yeah, let me text it in the chat as well. So yeah, you guys have it. So if you need to reach out, yeah, I'll be able to do a few consults tomorrow and also Thursday and Friday. And then SCB says, filed case in New York City, note of issues in January of 2025. How long would you think until pretrial conference and or trial date? Well, if you filed already the note of issue in January, probably like about a year, I would say, until the trial. It could be, pretrial conference could be 8 months, 7 months. It's hard to say. Like New York City, so that's Manhattan. They've been a little weird. Like, some people are waiting like 6-7 months just to get a preliminary conference. Like we even had a case where we kept writing to the court because we filed for a preliminary conference. It was in Manhattan, and they just were like ghosting us as nothing. It's like speaking to the void. And then finally we wrote a letter, and they don't even care about that. They're like, no. And then finally we made a motion, and they said, no, you can't make a motion. Read the part rules. But meanwhile, nothing's happening. And like, why can't we just get a conference? Before it was like 2 weeks you get a conference. 2 weeks. Now it's like, I don't know, 6 months. And then I went on the listserv, other lawyers, they're all complaining about it. They're like, yeah, we don't know what's happening. and it's only in Manhattan. And then we finally got one, so that was good. But I don't know what's going on with Manhattan. But I think with note of issues, hopefully they're not as far behind as with the preliminary conferences. But it's kind of more of a court administrative system for the administrative judge. So it's hard to say. And then Jorge says, "Hey, Mr. Arkady, I'm in deposition is in 2 weeks. My attorney hasn't sent the defense my discovery questions yet. I spoke with my paralegal and he said nothing to worry about. Is that accurate?" So you have your deposition in 2 weeks, but your attorney hasn't sent discovery requests out? Oh, well, discovery requests, like for example, requests for documents, that would be what your attorney needs to ask questions of the defendant. He wouldn't need those answered for your deposition, right? Because your deposition is more about your medical treatment, how the incident happened. As long as he prepares you, make sure he meets with you like 3 times. I like to meet with people 3-4 times, really prepare them, get them like comfortable, all the questions, all the answers, so they do a good job. That's what's critical, is that you do a good job in the deposition. But yeah, the discovery questions that you send to the other side, that's more like what you need in order to question their witness. That's important too, but you don't really need it for your deposition. And then Jason says, "Thank you for all the content and expert advice. There is no comparison to the feeling of being hurt, confused, and worried. No one believes you, on top of waiting for anyone to take you serious." Yeah, no, I'm sorry. I was actually thinking about that. I did another video today. I just recorded a few videos like about an hour before this live. And the other video I did was about this case that came down in New York. And it was interesting because it showed all what the defense does, right? And they really like try to poke holes in a meritorious case and argue, hey, is this from this little car crash? Or maybe this is from just like living your life, years and years of, grinding on a joint. And it's just, that's why it's a shoulder injury. They said, hey, it's just years and years of grinding on the joint. It's nothing to do with this little car crash. And then they try to like poke all these holes. So it kind of made me think of this quote from this book I read about pain, where it said something like, to have pain is to have certainty, but to hear about pain is to have doubt. So it's like, if you have pain, you're certain you have it. But if you hear about someone else's in pain, it just leads to like doubts. And that's what they're trying to do, is sow the seeds of doubt and then get people, the jury upset and get the jury to then vote for the defendant. So it's really unfair. So yeah, I'm sorry you're going through that. And then RG says, based on your experience, what percentage of truck accidents with truck at fault settle at mediation, and what percentage settle after mediation but before trial? I don't know about that. I don't know about like percentages like that, but basically, like usually if the truck is at fault, that's a good sign, obviously, because you'll have liability. So at that point, it becomes more of a question of the injury. If the injury is like really, really serious and you're trying to get a big amount, right? Depends on how much they have. Let's say they have 5 million and you say, hey, I have a big injury. I have like 2 fusions. I want the whole 5 million. Well, they may offer you something like 1 million, but they may not give you the whole 5. So then you have to like go a little further. You have to prepare it for trial. You might pick a jury, push them a little in court to show them, hey, we're serious. We can really get the 5. But if the injury is more like mild, like, I don't know, some epidurals or some herniations, but nothing too serious, no surgery, you might be able to settle it even at mediation or before, because look, it has a limited value, right? They'll say, hey, it's worth like 100 or it's worth 150. It's not really worth much more than that. There's no reason to really wait and waste time. So that's usually, I think it's more like a value question and being able to prove causation. Because fault is more, obviously fault is important. You need to have fault. Otherwise, if you don't have fault, why are you suing us, kind of thing. But fault isn't really what gets all the cases to settle. I think it's more of a value question of what the injury is worth, what you could show, and also the causation, meaning did this crash cause all of this, or was this just like from living your life or degenerative disc disease? Which is what the defense says. And then Frost says, if you have the burden of proof, can you file a lawsuit against the trucking company for 5 or 10 million with serious diagnosis and life story? Would the insurance try to take it all the way to trial? Yeah, I mean, you could file a lawsuit. Yeah, of course. I mean, if you have if you have a good case, like if the trucking company, if the truck hit you and the truck is at fault and you have a serious injury, sure. I mean, you always have the burden of proof, right? Because you're the plaintiff. But a burden of proof is just more likely true than not true, right? It's the greater weight of the evidence. So, for example, if the evidence weighed the same, it would be like equal. And if your evidence weighs a little more, well, now you've won, right? 51%. That's all you need to show. It's not like reasonable doubt, which is the criminal standard, right? Reasonable doubt means, hey, if there's a doubt, then that's an out, meaning the defendant goes home. He's free, right? If you have a doubt, it's a reasonable doubt, that's an out. In civil law, it's just the greater weight of the evidence. So whoever tips the scale. So it's much easier burden. And you have to explain that to the jury in jury selection, because a lot of the times the jury doesn't understand that. And they'll say, sure, I could do burden like that. I could do 51% if it has to do with liability, who's at fault. But about damages, if somebody's coming in here asking for tens of millions of dollars, I want them to show it by more of a certainty, maybe like 89%, maybe 92%. I don't want to give them tens of millions of dollars if they're only 51% right and 49% wrong. And it's not like a crazy thing to say, right? It makes sense, right? Wouldn't you want that if you're giving somebody, hey, tens of millions of dollars? But that's not the standard. So if they can't follow the law, then you get them off for cause. So a good lawyer knows how to like ask the right questions and hit those buttons. But yeah, absolutely. You could definitely sue. I mean, for 5 or 10 million. I mean, it's not really. It just depends on the injury. If the injury is really there, and yeah, life story is really important. I think like being able to show through witnesses, like friends, family, coworkers, and photographs, like anything from your iPhone, pictures. I think the more you can show a story, the better. The other good thing about it is like if you show the story, then it kind of neutralizes that whole defense, right? That you're a faker, a liar, cheater, or fraud. This is all orchestrated. They can't really say that. Wait, all these people are lying. Like my neighbor's lying. My priest is lying. My coworker from work is lying. People that know me are lying. People that don't know me are lying. But we're all lying. Like, wait a minute. So you have like a cross section of this person's life, and it becomes like absurd to say like all these people are, what is a big conspiracy? Everybody got together. They don't even know each other. So yeah, it becomes very powerful. Okay, and then My Blessed Life says, hello, everyone. Hi. Frost also says, policies 1 million. Can I turn down the $1 million for more? Well, I mean, it depends on what state you're in and all these different things. But usually what you would do if you want to get bad faith is you would give them an opportunity to pay you the $1 million. You say, look at all my injuries. All you have is $1 million. You have no excess. You have no umbrella. You're this trucking company. Pay me the $1 million. You have until let's say April 11th at 5 p.m. If you pay it, fine, it's settled. If you don't pay it, well, then if I go to court, it's not going to be $1 million anymore. It'll be 10. And then if the jury gives me 10, who's going to pay the other 9? This like ABC trucking company? Well, they don't have much money. They only have $1 million policy, right? They're a little mom and shop trucking company. So then the insurance company is going to be on the hook because remember, you had the clear chance to get rid of this for $1 million within the policy limits, but you chose not to. You chose to expose your policyholder who's paying you premiums for insurance. You chose to put them at risk. You chose to expose them and just roll the dice and see what happens to them. So let's see what happens to them. If they get hit, guess what? They're going to assign their right over to me, and I'm going to sue you for bad faith, and then the policy's open. So some states have that law, and you could do that. Like I've said, like in other videos, and that's actually an interesting topic, like which states have it, which states don't. I could do a little research into that. New York has very weak bad faith, so it's hard to do in New York. And then Diaz says, hello, I was to do sexual favors to continue working for the company. I had no choice. Oh, I'm sorry to hear that. I don't know. Yeah, that could be a lawsuit too. That could be a lawsuit, maybe an employment lawsuit or a sexual harassment lawsuit. Yeah, absolutely. I know some lawyers that do that. I partner with some lawyers that do like employment as well as sexual abuse cases. We work on some cases like with the Catholic Church, with the Boy Scouts, with some of those cases. Yeah. And Sandy says, my attorney is telling me that I have to prove it was Walmart's water on the floor that I slipped on. Is this true? I don't think so. I mean, what do you mean Walmart's water? If you slipped into Walmart, you have to prove notice, meaning like either Walmart knew about the water, Walmart had an opportunity to clean the water, or somebody complained about the water, and then some time went by, and then Walmart didn't clean the water. But it doesn't have to be their water. You know what I mean? You mean their water in the sense that it was on the shelf, like they're selling water and that's what spilled? I mean, that could be a case that's caused and created. But even if it's not their water, let's say a patron brings his own bottle of water from outside, but he spills it in the aisle, and it's on the video that he spilled it. It's on the video when he spilled it. He spilled it at like 1 p.m. And then like 3 p.m., 2 hours later, you come walking, you slip. They're still liable for that because they had 2 hours to find it and clean it up. So it's just notice. That's all you have to prove. So yeah, so that's how that works usually. And then Jorge says, my discovery answers, I mean. Oh, your discovery answers. I mean, it depends on the questions they're asking. Every state has different rules. Like in New York, we have requests for discovery. Some states have interrogatories. So it gets a little complicated. I'd have to look at the actual questions. But yeah, I mean, your discovery answers should probably get served before the deposition. Otherwise, the other side just won't do the deposition. They'll say, hey, we'll get an adjournment, And then Chris says, thanks for all your videos and also your recommending attorney. Oh, no, absolutely. I'm happy to help. And Madame says, hello, lawyer. Said the insurance refuses to pay $750,000 for truck accident and cases going to court. How much money will it be now? Who's paying the lawyer expenses if I win? Well, no, the lawyer, if you have a lawyer, usually the lawyer will take a contingency, meaning a third. So if the lawyer gets you, let's say, $1 million, you get 700, the lawyer gets 300, if it's 750, whatever, a third of 750, what, 250 and 500, whatever it is, that's usually how that works. It's the same, it's just contingency. Let's see, let me go back up. Make this a little bit bigger. So we did the question. Rain and Dreams has a question. Is it a good thing when the company and general contractors have to do depositions also before I do? Before you do, you mean you're suing somebody and then the company you're suing and the general contractors are doing the depositions before the plaintiff? Usually it doesn't happen, right? Usually the plaintiff goes first. But I guess, yeah, if they have to do some kind of deposition earlier, it's not really good or bad. It's just, timing, who goes first, but it's fine, I think. And then Marquita, do you think Publix will take my case to trial given my cerebral palsy, fusion surgery, and ADA violation evidence I've gathered? It's hard for me to say. I think the first thing you have to do is, get a lawyer, file a lawsuit. Remember, that's day one. You just go step by step, file a lawsuit, see what they say. If there's a trial lawyer involved, maybe they'll take a different position. Maybe they'll, offer you a settlement but if not, then yeah, that's what you have to do. You have to just prepare the case as if it's going to trial, and then that's where you can get more money too if they're not being fair. And then Chris says, what about commercial accident? And I've had an arthroscopic knee surgery, and now the doctor is saying knee replacement. Should it be a good recovery? Yeah. If you've had a scope, that's arthroscopic, and then you need a knee replacement. Knee replacement is much more serious, so yeah, it should be bigger. Like I had a scope case with the need for a knee replacement. The client did not have a knee replacement, but if it was just a scope case, it might be like 150. But if it's a scope case with the need for a knee replacement, I think that one settled for like 650, right? So it's much bigger. And if you actually have a knee replacement or a hip replacement, it could be even bigger than that. Like we just did one for like 1.25 million. So yeah, it's much bigger when you have the knee replacement or the hip replacement. And then RG says, about the previous question, the injuries unfortunately make me have a cervical fusion at C5, C6, 1 million in coverage, but there's also an arthroscopic surgery, there's post-traumatic stress disorder, depression, and 6 months of therapy. Oh yeah, so if you have all those injuries, I would think it's a tender. I don't know what state you're in, but it should be a tender, because if you're suing for medical costs plus lost wages plus pain and suffering past the future, depending on your age, how would that not be all those different elements of damages? How would that not be a tender? They should just give you the 1 million if that's all they have. But find out, because they might have excess and umbrellas and you can get more. And then Irish says, we are suing our 2 auto insurance along with the driver's 16-year-old parents, do we expect the same percentage of payout from each insurance company, or would one pay a policy limit and another a percentage, neck herniations and TBI? Well, yeah, that depends. I mean, the amount they pay usually has to do with liability, right? So if you're suing two different cars and each car has their own insurance, it just depends on like the percentage of fault for how the crash happened. So if like one car, let's say, changed lanes, but the other car was in the lane, the car that changed lanes was mostly at fault, so that car would pay more of a percentage. And if you're like a passenger in the car that just stayed in this lane, you didn't really do anything wrong, they might contribute a little bit, but they're gonna say, well, what did we do wrong? We just stayed in our lane, the guy changed lanes into us. So it depends on like that's usually how the percentages get split, is based on the theory of liability. And then Jason says, can an insurance company cut off treatment due to what they are calling a lack of damage to the car? $8,000 car total. No, usually they don't cut off treatment for that. Usually, I mean, again, I don't know what state you're in, how it works everywhere, but like usually the way they do it in New York, at least where I am, is, they have to pay for your treatment until you've reached what's known as like either maximum medical improvement, or until you see their doctor and their doctor says in one of the IMEs, hey, you don't need any more treatment, then they cut you off. So, but it's usually like 3-4 months after the crash when you've been able to get most of your treatment paid for. And then Moha says, does the lawyer fee automatically go up to 40% for just filing the case in court, or they have to litigate and then it goes up to 40%? What if it settles while the case is pending in court? Well, that depends on your retainer. You just have to read your retainer. I think a lot of lawyers, what they do is they say pre-litigation, like as a claim, it's like 33 or 30, but once they file a lawsuit, now litigation starts, so it's 40. So just as long as litigation starts, so even if they just go to court and they file it in court, nothing has happened, right? It's just a piece of paper that they press a button and the computer prints it. It takes like 10 minutes. And then they go and they file it and they pay their filing fee. It's like $210. Well, now it's in court. You could say, well, now litigation started. Now it's 40%. So yeah, a lot of lawyers do that. We don't do that here. I mean, I just charge a third, 33% across the board, no matter what, even if I'm doing appeals and litigation and trials, but a lot of places, they do that. They go up to 40, whether it's in like other states, like I don't out west, like I think California, right, Arizona, a lot of places they do charge 40. So I know people don't like that. I guess people want to charge less, but if you think about it, I mean, it is a difference in money, but what is it, like 7%? But you have to think of it this way too. If filing the lawsuit is what led them to pay you, let's say $1 million, well, it's better to pay 40% but get $1 million and then pay like 30%, but then they're only getting you, pre-litigation, they're not gonna be able to get you much, because if you're not in court, there's no, there's no hammer. There's no reason for them to pay you. They could be like, okay, so what are you gonna do? You're gonna paper me to death? You're gonna call me and talk to me on the phone, make me pay? Like, why? I don't have to pay. It's just a claim. What's a claim? You're asking me for money. I say no. Make me pay kind of thing. And that's the way you make them pay, is by going to court. So if you're not going to file a lawsuit, what are they going to give you? Like maybe they give you like 30,000 or something. But if you go to court, hey, they're going to give you much, much more. Sometimes 10 or 20 times more. So it's worth paying the extra 7%, but you're getting a much better amount, as long as you have a real trial lawyer who has a track record of success, and that's all vital as well. Okay, and then RG says, how important are previous similar case settlements or verdicts in the same county to get a fair compensation and mediation? For example, in 2020, a similar case settled for $900K. Yeah, that's important. I mean, like I do that when I write my settlement letters. I sometimes actually look at verdict search. And then I say, hey, these are verdicts that are similar, because the insurance companies, they really care about that, right? Because if you could show them, hey, I'm in the same county, like Kings County, it's the same kind of case, truck crash, whatever, rear end, same kind of injury. Look, and they got like 8 million. So why won't we get 8 million? It's a precedent, right? And you show other cases. So I think that's helpful to do. So I definitely do that in my letters. I recommend doing that. And then Mose says, hi, Arkady. Hi, how are you? And Preacher says, if bad faith is hard to do in New York, do you have to take whatever the policy limits are? I mean, look, sometimes you do, but I still push the envelope. I still do the bad faith letters. I still do that whole thing where I say, look, pay me within the policy, and if you don't, then it's going to be much more, because I like to push their buttons. I kind of show them, like, I don't want to negotiate the way they negotiate, because they basically say, what's your demand? And then if you say something high, like $1 million, say, oh, $1 million, that's ridiculous. I'll come down to 200. If you come down to 200, we'll have real money for you. And then you come down to 200, and then say, okay, well, we'll have 30,000. And if you come down a little more, but guess what they've done just now? You can't then go up and say, no, you know what? On second thought, I'll go back to 950. You can't do that, right? Because once you come down like 200, you've already saved them 800,000. So now they're thinking, the way they think is like, oh, we have $1 million. That's the worst we could ever have to pay. Well, now 800 is safe. Great. Now we're just playing with the 200. And now let's give them 30. Maybe we'll get rid of it for 70. They'll give you a third of what you're asking for, what you're demanding. So now you're demanding 200. They'll give you like 70. That's about a third, right, of what you're asking for. Try to get rid of it for that. And meanwhile, if you take 70, guess what? You've just given away $930,000 off the million, right? So that's the way I think of it. I'm like, no, wait. So you have to know how to push their buttons. So the way to push their buttons is to say, look, pay me whatever. It doesn't always have to be $1 million, right? You have to know value and know, like we just talked about, precedents, right? Or what other cases settle for. But for example, you could say, hey, this is worth X, this is worth 600, pay me the 600. If not, then fine, I go to court. But you only have $1 million. And if I go to court, I might tell the jury that fair and equitable compensation in this case is $2 million. And if they agree with me and they give me like 1.75, who's going to pay the difference? Who's going to pay the other 750, right? Or the other $1 million if I get to $2 million? Because all you have is $1 million, and then your policyholder, your insured, is left exposed. So they don't like that, because they have a duty of good faith and fair dealing to their policyholder. So then they don't like that. That usually it always leads to something. Either they settle, or they fire their lawyer, hire a new lawyer, or they call you up screaming, ripping their hair out. But it always leads to something. So it's fun to do. But I like to push their buttons. I don't like to negotiate the other way. A lot of lawyers negotiate, I don't know why, they negotiate the old school way. Like even this week, somebody called me and they're telling me this story. I think it was in another state, and she gets rear-ended by a car, and the lady, it sounded like she had pretty serious injuries, like brain injury, PTSD. And she's saying, like, there were different cars involved. So every car put in like 20K. But one of the cars had a 1 million excess policy and a 250 primary policy, right? So that's 1.25 million. So they're putting in 20K. So wait a minute, so that means they're trying to save $1,230,000. It's just like saved. And they're putting up 20K. I mean, come on. And the other car only had 25,000, and they're putting up 20K. Okay, well, that makes sense, right? They only have 25. They're putting up 20. They're saving 5,000. I mean, maybe they should put up the full 25, but whatever. But these people are trying to save 1.23 million. It's, come on, on serious injuries. So that's when you need a trial lawyer to really come in and push their buttons. Okay, let me see. What other questions do we have? Sandy says, I slipped and fell in front of the freezer at Walmart. It's on camera. We're in mediation. They're saying I have to prove that the water on the floor came from them and that they knew it was there. Well, no, I mean, it's just notice. That's all it is. There's 3 ways to prove notice. Number 1, actual notice. If somebody complained and said, hey, you have water on the floor, and they said, yeah, okay, we'll clean it, and then they don't, and then someone falls, that's actual. Constructive is just if the water is there for a period of time. Like, for example, you see the water at like 1 p.m., right? Or somebody sees the water. Joe Blow sees the water at 1 p.m. He'll just say, I was shopping at Walmart. I'm Joe Blow, and I saw water at 1 p.m. That's it. That's all he has to say, right? And then you fell at 3 p.m. So 2 hours later, the same water is still there. That's constructive notice. Or the third way is caused and created. If they had some problem with their freezer, they didn't fix their freezer, the freezer leaked, and then they caused and created the leak. It's their fault. So any one of those 3. So it doesn't have to be like their water, but if it's from the freezer, it's probably their freezer. Who else? Do other people bring freezers to Walmart? I mean, of course, if it's their freezer, it's their Walmart. I mean, Walmart is a whole other story. I could tell you, I actually watched also Continuing Legal Education on Walmart, and they have, I don't think I ever did a video about it. I probably should. I have to watch it again. It's very intricate, but they have a whole system. I mean, they're really, really, I mean, they're a huge corporation. They have all these like systems. And the interesting thing about them is the way they're set up is that their home office, I think, is in like maybe what is it, Alabama or Arkansas, but they get reports from like all the different other Walmarts, right, in all states, all over the country. But they don't have, the communication is like one way. So like say the Walmart in like, I don't know, Oklahoma, right, will then send a report to the headquarters in Arkansas. Hey, there's a problem here. They receive the report, they put it in some claim file, but they don't actually do anything about it. Like, and there's cases like that have been won on that because they actually prove that. Like, for example, high traffic areas in stores where people walk near the cash registers. They know about it. They call it like Action Alley. Why is it called Action Alley? Because everyone walks there. There's action. And they know it's wet. They know people fall. And they don't care. They just, because all communication just goes one way. And there's more. It's a whole interesting thing. I have to watch it again and do a whole video about it. But Walmart is like real. If you have a lawyer that knows how to sue Walmart, you can get a big amount of money if it's a serious case. I think those could be good cases. But yeah, I wouldn't worry about a case like that. That's a good case. Like, just if it's their freezer, just get, if you have any witness, like you were shopping with somebody, like your friend, anybody who says, hey, I saw the water, or you get discovery from them. Have you had any issues, maintenance, repairs to this freezer? You could also get a corporate rep deposition. What are your policies and procedures? You could get former employees, maybe somebody who used to work at the Walmart, doesn't work there anymore, and maybe they're not happy, right? Because they got fired or they quit, and they're like, that Walmart, they never fixed their freezer. They always had water there. And then any of those are ways you could prove the case. It's usually not too hard to prove notice. And then Chris says, thank you. I'm in Nevada. Really appreciate it. Oh, yeah, absolutely. I'm actually, doing some cases in Nevada right now with other lawyers. So, yeah, absolutely. And then the machine says, I'm so scared at this point. My trial date is in May, and my surgery is still pending approval, my MRI appointment, and I'm not sure if my lawyer will be able to reschedule the court date in time. No, I wouldn't worry about that. I mean, look, if you haven't had your surgery, you just, you just tell the court, and they'll give you a new date. I mean, worst comes to worst, you can knock the case off the trial calendar if you really want to get your surgery done, and then you just file a stipulation to restore it back. You could do that, and then when they restore it back, you don't start at the beginning of the line anymore, right? You don't go back to the beginning. You start where you were, so it's a quicker wait after you restore it back. You could do that, or you could just go to trial without the surgery and just have the doctor talk about you need the surgery, just waiting for approval. You're going to have it. That's good too, because you say, look, I'm not, because they're going to say, are you still treating? Are you going anywhere? That's what they love to say, right? You're not going to go anywhere. You're not treating. You haven't been anywhere in 2 years. Well, they can't say. Say, no, I just been to the doctor. In fact, he told me I need surgery, and my surgery is scheduled for in a few months. So then the jury's thinking, oh my God, I have to give this guy money because if he's going to have surgery like in the next few weeks, right? So I think that makes the case either way. I think you're okay. I mean, honestly, like having the surgery is probably worth more than just needing it and not having it. But either way, it could be, if it's framed the right way, if the lawyer knows how to handle it, either way, it could be powerful. And then Mike says, hey, Arkady, if a rental hit me, they have $1 million coverage, but I'm not sure if the driver purchased insurance. They said they have that in coverage. If the driver didn't purchase anything, will I get? So you're saying that a rent-a-car hit you, and then they have $1 million in insurance, but you're not sure if the driver purchased the extra insurance. I mean, they'll usually tell you. They'll show you the contracts if they purchased it or not. They'll usually just tell you. But I think, depending what company it is, you still might be able to recover against them. It doesn't necessarily have to be like a minimal. Of course, if they purchased, more, you have more. But if they didn't purchase more, it's still going to be like, if it's the rental car, like if it's an enterprise or budget or one of those big companies, it still could be pretty large. So. But you just find that out. That's not hard to find out. Just ask them. And then Mose says, my lawyer said I did a great job in my deposition, but my question is why the defense attorney didn't ask me what are the things you can't do anymore. Well, every lawyer has like their own style. Some lawyers don't ask that, I guess. I mean, most lawyers will, but some lawyers, I guess, don't. And then he said, my lawyer thinks that they see me as a good witness. Well, that's good. That's good. Yeah, you always want to be a good witness. That's always going to help you settle. And Irish says they have admitted complete liability or rear end collision. Okay, that's good. Yeah, rear end is always powerful. There's always, you can get summary judgment on that. At least in New York, if you get summary judgment, then you get like 9% interest on top of the amount, you know. So that makes the case even better. And it makes them want to settle because they don't want to pay you whatever your damages are plus 9% for all those years. It's 9% every year, you know, so it's like a big, it's almost, 9% every year. So it's a big interest rate on top of whatever the judgment is. So that kind of gets them to try to settle. And Lewis says, Arkady, the man, the myth, the legend. Thanks again for the video. Always great info. Hope for the best. Expect the worst out of my lawsuit. No, good luck. Good luck. Hopefully, don't expect the worst. Hopefully, you get a good result. And A24 says, I was rear-ended by a truck, and the last thing the doctor told me is I need a disc replacement surgery. And the court ordered mediation after 3 months. Recommend surgery or wait? Well, I mean, if you got rear-ended by a truck, if the doctor thinks you need the surgery, I mean, that's really a decision you have to make with the doctor. If you feel like you're in so much pain, you can't live without the pain, you should get it because the doctor's recommending it, and go ahead and get it. If you feel like you're okay, you don't really agree with the doctor, you can get a second opinion. But yeah, I mean, in terms of the case, getting the surgery is going to make the case more valuable than not getting the surgery. So that, I can tell you that. But yeah, if you have court-ordered mediation and if you have the surgery now, in 3 months when you have the court-ordered mediation, you might settle, or if not, then you'll have a much stronger case for trial. And then Curtis says, hey, what can I do if I have a hard time working? I can't do half of what I used to. Yeah, it's hard. I mean, when people have serious injuries, you know, unfortunately they can't, that's one of the things, they can't work. So you just do your best. You try to work, or sometimes people go on disability, or they, you know, they do part-time work, or they do some other kind of, but it's hard, right? Because if you've always done like a physical job, it's hard to get like a desk job because you don't do the desk jobs. You don't know how to do them. You have to it's a whole new vocation. So there's not really an easy answer to that. That's why the cases could be so valuable, right? Because you have these lost wages, you have these tremendous, like life-changing, forever injuries. And Willie says, good evening, Mr. Arkady. Good evening, everyone. Hi, how are you? And James says, what is the next step after your lawyer has served papers to the convenience store you fell at? Okay, so if they serve papers, that means they're starting lawsuits. And then the next step would be that the store gives the papers to their insurance company. The insurance company hires the defense law firm. The defense law firm answers and appears in the case and says, hey, we're going to represent the defendant. And then you have the preliminary conference and you start discovery. And Sandy says, thank you for hearing me out. You're great. Oh, yeah, no, you're very welcome. And if you want, just text me. I'm happy to chat with you as well, because I don't know if I, explained everything. Maybe I could give you some pointers if we speak. And then Sadie says, good afternoon. I have a workers' comp and premises liability case. Will I receive one settlement or two? Oh, yeah, so that's two, right? Because it's separate usually. So the premises liability is the third-party action against the whatever happened. And then the workers' comp is more like to pay for your lost wages, to pay for your medical bills, which is really money that goes to doctors and, other people that give you treatment, but you get that paid. So it's almost like insurance, right? Workers' comp is almost like insurance. It pays for your medicals, but it also reimburses your lost wages or your paycheck losses. But that's like, if you get a settlement from workers' comp, you can, and that's in New York, that's known as a Section 32. So instead of getting, let's say, smaller checks every 2 weeks, you get one big check for, let's say, 100, 200,000, but then you stop getting the smaller checks. But that's a settlement with workers' comp. That's separate. And then you have another settlement with the third-party lawsuit, which is just like any case, right? If it's a car accident or slip and fall, you sue the entity that was at fault, the defendant. But when you do that, obviously, you don't sue your employer. You cannot sue your employer. That's where the workers' comp comes in. So they give you the benefit. And then Moha says, hit the like button, people. Arkady puts a lot of time here. Oh, thank you so much. No, absolutely. And Jeannie says, do car accidents usually settle after deposition? I would say, yeah, usually they do. I mean, the deposition is like their chance to really like question you, right? Find out what happened, find out who you are, your story. So that's kind of like, if they haven't even done a deposition, they could offer you a settlement, but usually it's going to be like small because they don't even know who you are, how you present, how you answer questions, what happened, right? They only know based on the police report or based on what your lawyer tells them. So they want to hear from you. And then Tony says multiple herniated discs, 6 knee tear, rear end, 100% other pardon fault. Average results in Manhattan, no surgery. So it's just herniations with a knee tear, but no surgery in Manhattan. I mean, Manhattan, it depends. So it's 100% at fault. Depends on what the policy is, right? If it's like, say, 100 policy, look, if you have herniations, you have knee tears, if you have a doctor saying you need surgery, but you just haven't had it, it could be worth, I don't know, it's hard to say. It could be worth 50, it could be worth 100. I've had cases go for even 150, and they were just like epidural steroid injections, but no surgery, like more soft tissue. But of course, the more things people do, like surgery, the more, you could show that it's serious, the bigger the amount. But usually it depends on the policy. Like if it's a 25 policy, then you're limited to 25. If it's a 100 policy, limited to 100. If it's a million policy, okay, it could be. It's probably not going to go a million if it's just soft tissue, but you have potential. I mean, you definitely have potential. But yeah, usually that's what they go for, though. Manhattan is not the best venue. It's not the worst venue. It's kind of like an okay venue. I mean, it's very. You have a lot of very, conservative people, Manhattan, wealthy people. They may not want to give too much money, but then you also have some other. It's very diverse, of course. It's Manhattan, but you could do fine there. The last case I did there, we did well. We got 1.25, almost 1.3 million, and it was actually a hip replacement surgery, but the client needed it before the fall. He also had a fall, and he needed the surgery before the fall. So he already, doctor was telling me he needed surgery, but the fall, made it a little worse. We argued that it was an aggravation, but it was kind of like a tough argument. That's why, we ended up settling it. I think the client was happy. And Flavor Shot says, if an attorney tells a client, I don't believe your case will require a trial, is that a sign that they feel pretty optimistic about mediation or settlement? Yeah, I think so. I mean, probably it just means that they don't think that it's going to need to go all the way to trial for whatever reason. You could ask them why, right? It could be because the case is small, so small cases usually there's no reason to try it. It could be that it's really clear and the injury is really serious and they think that you're going to be able to get a fair settlement. But usually it's a good sign. And Sade says, I've had arthroscopic ankle, 2 shoulder, rhizotomy, cervical and lumbar discectomy, and multiple epidural injections. How much do you think I can receive? Yeah, I mean, that's serious. I don't know where you are in terms of like venue. That's the case. Let me go back up. That's the case where, the workers' comp and premises liability case, right? Let me see. I mean, I could tell you in New York, like arthroscopic ankle, 2 shoulder surgeries. So if you had 3 surgeries, I mean, could be right there. That could be like 600,000-700,000. And then if you have a discectomy, I mean, I've had one discectomy case, I think it was a cervical discectomy, just one, and it was like 550. So if you had 2, right, plus you had 3 arthroscopic, that's 5 surgeries, right? That could be into the millions, I think, potentially. That could be a big case. I mean, and on the epidurals as well. So, it just depends on everything in terms of what happened, what's the liability, where you are, who's preparing the case, are they preparing it the right way, right? What's the human story? What's the overall like life-changing forever injury that you're showing? So it's like a puzzle. Everything has to fit. It's not just like I have these procedures, right? Somebody could have procedures, but just not be able to explain how it affected their life. And then the jury might think, hey, you know what? They had 20 procedures, but they sound like a fraud. Send them home with nothing, right? It's possible. So it just how everything fits together. But I would say, look, based on all what you've said, if the case is prepared the right way with arthroscopic and 2 shoulder, 1 ankle, that could already be 3 surgeries, could already be like 300, right? And then you have cervical and lumbar discectomy. So those 2 discectomy surgeries could be another, 200-300. So you're talking like 600, I think minimal, could be much more. And then James says, thank you so much for the time that you share with us. Oh, you're very welcome. And Elliot says, I know you're not a medical malpractice lawyer, but I have a contract case against the nationally known dental office. They've been sued in small claims in my county a dozen times, but always. Do you think this is because they're settling before court or something else? I'm not sure. Not sure I'm understanding the question. So you're saying you have a contract lawsuit against a dental office, and they've also, this same dental office has been sued in small claims court, but they always They always resolve? I don't know. I think it disappeared with message or something for some reason. Maybe I hit the wrong button. It just says, but they always. I don't know. And then it stops. I mean, it could be that small claims court cases are usually small cases, right? They're usually like cases for like $500, $1,000. I think the most you could sue for is like 5,000. So they usually settle, or sometimes people just don't show up. The cases get dismissed. So, it doesn't really, it's hard to say what happened. You can ask the clerk. Small claims is actually, it's meant for people to do without a lawyer, right? That's the whole purpose. That's why the court is like at 6 p.m. or 7 p.m. Well, it's meant for people to do everything without a lawyer. You don't even need a lawyer. So it's very simple. You can agree on an arbitrator, which is usually like a lawyer or a judge, or you can go all the way to the judge. But it's really relaxed rules. So if it's like a contract case and they didn't do something right, you just have to show up and explain everything clearly. You could win that. And so, yeah, but I do some medical malpractice, but medical malpractice is different. Remember, medical malpractice is if you have like an injury that's really serious, like a life-changing injury. And then when you sue for the medical malpractice against, let's say, the doctor, the hospital, that could be a big case. Like I had a medical malpractice one for like 1.5 million, or some even go for more, like into the millions. But if you're talking about small claims, that's usually like 5,000 or less. So, yeah, so if they've been sued, but I mean, they could be settling as well. If they're national, big dental practice, whatever, they might just be like, yeah, give them like $500, whatever. Get rid of these cases. They probably have counsel that handles those for them. And then Joel says, good evening, Arkady. UPS rear-ended me, and I'm actually going in for lumbar percutaneous discectomy, and they want to do a neck fusion. What do you think ballpark this is worth? Yeah, so I mean, UPS obviously has, money, so that's good. If they rear-ended you, if it's like serious property damage, or you have some crushed metal, some kind of damage. Perc disc, like I said, I just did one. We got like 550, so you could do well with perc disc. And then if you have a fusion, well, that's even much bigger. So if you have lumbar perc, that could be like anywhere from 150 to like say 550, that range usually for the lumbar. And then fusion could be $1 million or more, depending on where you are and all the you'd have to look at the precedents in New York County, the verdict search. But yeah, it could be easily worth, if you have lost wages as well, and need for future medicals, right? If you have like a real trial lawyer prepping it the right way, it could be easily worth, let's say, $1 million here and like 1.6, 1.7, and that's more like conservative, right? Just it could be more than that. And then Jeannie says, the fact that you find the time to do this is so awesome. You don't know how much pressure you take away from us. It's not always easy asking our lawyers questions. Oh, no, I'm happy to help. Thank you so much. Yeah, I'm glad that it's helpful. Sometimes I want to help more, but I just feel like the questions are sometimes, I can't answer because I just need more parts to the puzzle. So it's not that I'm trying to be too general, but no, thank you. That's good that it's helpful. And yeah, feel free to reach out for a consult as well. I've been doing consults with people. I think I did a few this week, and I'm happy to do more. And Jeannie says, oh no, we did Jeannie. I'm sorry. Joel says, accident is from South Florida, and I have a good trial lawyer, and thank you for all the videos. Love your passion. Oh, that's awesome. Yeah, that's important. It's important to have a good trial lawyer, somebody who's going to be able to get a big amount. Yeah, absolutely. And Marquita says, a claims adjuster from Publix said that if I knew I have a disability, I should have taken someone to shop with me or gotten a store associate to help me. Is that fair? No, I don't think so. I mean, it really like depends on like, you know, all the facts and circumstances. But like, I think this was the one where you were in a scooter, right? And you got up to get something from the aisle and they blocked the aisle because they just left like beer boxes, but it was just, you know, kind of negligently strewn across in a haphazard manner. So you tripped over it. So I don't think they could blame you. I mean, they always want to blame you for whatever. Or you should get an associate, or you know, if you knew you had a disability, it's your fault. But they always want to blame other people, basically point the finger, right? Not them. It's never them. You know. So you just have to show that, wait a minute, it is you. Why did you leave this beer here, these boxes in the way? Like, I'm a shopper. I got up from my chair. I have a disability. I want to be able to get something. You're not supposed to leave this here. Just put it away. There's no reason to leave it here. Either put it on the shelf where it is for sale or leave it on the hand truck in the corner. What's the purpose of leaving it in the walkway where people are walking, right? Like Action Alley, like Walmart, right? Action Alley, that's where everyone is. What's the purpose of leaving it there? You know, how is that not? Negligence is just the failure to use reasonable care. How is it reasonably careful to take, you know, beer boxes and just leave them in a place where people are walking back and forth, maybe walking this way, you know, it's not reasonably careful. So I think you could win that case. So yeah, I think that's I would, you know, of course it depends on like your venue, your jury. I mean, you know, some jurors might believe that argument, right? Like you said, that you caused your own injury because you shopped independently. So you have to explore that with the jurors. When you pick a jury, when your lawyer picks a jury, you have to ask, hey, do you think somebody might cause their own accident, you know, just because they got up from a chair? But if you're allowed to get up from a chair, you've done it before, you haven't fallen before, you know. So I think it just depends, but you have to like just kind of front all the issues and in jury selection and get a fair, impartial jury. And Sadie says, thank you so much for your insights. Oh, you're very welcome. And Sandy says, can you post the number to text you? Oh, yeah, let me post that again. Yeah, I think I posted it. Let me post it again. Yeah, it's just 347-566-9595. And Come Along says, thank you for all your insight. You are a true champion of the people. Oh, thank you so much. I appreciate that. And C. Bautista says, what happens if your attorney suggests to settle the case based off an online survey that came back not too much in my favor, 30 versus 70, and they were provided with basic information about your case? I don't know. I've never heard of that. What do you mean an online survey? Oh, like a focus group? He did a focus group, and the focus group came back. Well, you can't really like rely if it's just one focus group. You have to do a few of them, you know, because when you do a focus group that's small, a small sample size, it's just like 10 people, you know, so those 10 people could think one thing, but then the jury, there's 10 other people, they might think something completely different. So you have to do a few of them. If you're doing like say 10 focus groups, and each time it's like 10 or 20 people, and they're always saying that it's like say you would only win 30 and 70 is against you, then it's more of like a better sample size. But I know some lawyers do focus groups with like thousands of people, and it's actually very, very accurate. They'll say, hey, in this case, ask for like, you know, 19 million and you'll get like 16 million. And then the lawyer asks for like 19 million and he gets like 16 million. It's like, they knock it down to a science, but you have to get like thousands of people to do that. And then Elliot says, it's over the dentures in a day. I'm 33, all the teeth pulled, still no teeth. We're supposed to be implants, still 0 teeth after 3 years. Attorneys won't take, not worth enough. Oh, they pulled all your teeth. Oh, it's terrible. Really, 33. I don't know why the attorney wouldn't take that if they're lying and it's been 3 years and you have no teeth. I don't know. Dentures in a day. I haven't heard of that, but I would think that's a serious injury. I don't know. I mean, feel free to text me. I could maybe try to help, try to find someone for you. But yeah, that sounds like serious. And then Come Along says, 3 years of physical therapy. Is it okay to tell the doctors you don't want to go no more? Yeah, I mean, you could if you had 3 years. I mean, also, you know, usually the doctor will tell you, hey, you've reached maximum medical improvement, so you can keep going, but it's not really going to do anything for you at a certain point. And then Nayslayer says, what if I showed up at my deposition dressed like a tortilla? Oh, yeah, that's a good idea. I don't know. How would you, like a Halloween costume? like a tort. Oh, a tort, like a tortilla. That's good. I like that. And Come Along says, haha. And Mello says, hi, I just sent a settlement. Why is it taking so long to sign the settlement agreement? I mean, I don't know. You mean like, oh, you took a settlement, but they're not sending you the actual release to sign? I mean, it could be that the lawyer's drafting it, or it could be you have liens. Liens are like if you owe Medicaid, Medicare, doctors, funding companies, and then they have to work out all the numbers, who's going to get what, get reductions. It could be that. It's hard to say. To sign it, it doesn't take long, right? You just sign it. But to get the documents sometimes and to work out all the numbers and who's going to get what, sometimes that could take some time. And then Wen says, had a ceiling collapse in 2020. I had 3 epidural injections and a percutaneous discectomy, and my trial date is in August. My worry is I had a felony in 1995 on disability fraud. Could that hurt my case? Yeah, I mean, like, it's possible, but you just have to either see, there's two things. The way you deal with that is you try to make a motion in limine to preclude that, right? And you say, look, there was some kind of disability fraud. It was in 1995. That's like 30 years ago. So you say, look, everything's changed for 30 years. I've been, normal person, and I paid my debt to society, right? Whatever it was, if you had to do probation, if you had to serve jail time, whatever your sentence was. Oh, excuse me. So whatever your sentence was, you already paid for that, right? 30 years ago. So why do you have to pay again now for your case? What does it have to do with your case? Your case is separate, right? It's like 2 different things. It's like you have your life story. People have life stories. People die, cancer, whatever, right? Crimes, drugs, mistakes, good things, bad things. It's life. But you paid your debt to society, right? And now you have this case from 2020, which is it's 25 years later, and you had injections, you had a percutaneous discectomy, you have a trial, you didn't ask for the ceiling to drop on your head. So you just have to separate that and have your lawyer separate that. So I would make a motion in limine, but if the motion in limine is denied and the judge says, well, this is a crime of moral turpitude, I'm letting it in, then you just have to front it. And what I mean by that is just have the lawyer go up and voir dire when he's picking the jury and say, look, would you hold that against my client? I want to be honest with you. It's going to come out that she had or he had this thing 30 years ago with some kind of felony, disability fraud. Can you give them the same fair shake that you would give somebody who didn't have a disability fraud, right? And if they say no, I'm going to hold it against them. Well, guess what? Get rid of that juror for cause. You have unlimited cause challenges. So that's for cause. That's a reason, right? They can't be fair. Get rid of them and just keep getting rid of all the people that can't be fair until you have only the jurors that say, well, I don't care. I'll be fair. Whether they had this disability fraud 20 years ago or they didn't, I'll be an equal playing field. They'll both start, exactly. If it's a race, if it's like a foot race, they both start behind the same line, right? Then it's fair. So that's what you want. So yeah, I would just do it that way. I try to motion in limine, but if you can't, just voir dire on it. I don't think it's such a big deal, but a lot of people, everyone has their own opinions, right? Every person is different. So some people might, depending also where you are, if you're in a conservative jurisdiction, they might think differently. And then Mellow Fellow says, took settlement. Oh, we did that one. Okay. Flavor Shot says, my partner slipped and fell, had an ORF done on her ankle, bimalleolar fracture. Oh, that's serious. And now has chronic pain in the foot. Her surgery involved 13 screws, 2 plates, and an anchor. Real rough. Oh yeah, I'm sorry to hear that. That could be a big case. That could be, even into the millions. A case like that for sure. And then, C. Bautista says it was based on 150 people. Oh yeah, if it was that many people, it could be, some merit to it. Could be some merit to it. And then C. Hampton says, can you tell me what's the difference between a denial and a stay in workers' comp? Well, I don't do workers' comp, so I don't want to, I'm not sure, but I think usually a denial just means what it says, right? That something is denied. But for example, you ask motion, can I have more time? And they say, no, it's denied. It means you're not getting more time, they deny. And a stay just means it's like an adjournment. It's stayed. When you stay a case, nothing's going to happen. So for example, if I say, hey, the defendant filed for a bankruptcy. Now the lawsuit is stayed. It means there's like a moratorium, that the lawsuit is just dead until you go to the federal bankruptcy court and you lift the stay. Now you've lifted the stay, which is the, and now it's active again. So yeah, usually that's all it is. So it's a stay is just like a postponement, or nothing happens, and a denial is when they deny something. And Marquita says, thank you. Oh, you're very welcome. And then there's a question. Hi, Arkady. Is pre-existing condition means the case has issues? Thanks so much. It could. You just have to, like I've talked about this many times, you just have to show that the injury was made worse, or rather the pre-existing condition, whatever the condition was, that it was made worse by this trauma, whether it's the fall or the crash, right? You can't sue for what you already had before, right? Because that wouldn't make sense, right? Let's say I have a condition, right? Like I have a herniated disc, let's say at C3, C4. Then I go to Walmart and I slip and fall in a defective, dangerous hole. And then guess what? Now I have a C3, C4 herniation, but I already had it before. I can't sue for it, obviously. But if my C3, C4 herniation that I had before was like not giving me any problems, I just had it, I know I have it, okay, great. I go to work, everything's fine, I'm playing baseball, whatever I'm doing. But then I have this fall at Walmart, and now the doctor says, well, now the C3, C4 herniation, look at it. Before it was just a little bit, now it's big herniation, you got to have a fusion. Well, now I can sue for the fusion, you see? So that's how it works. It's to the extent that it was made worse. And then Robin says, if I settle one part of my case, can I receive that side of the money? I was a passenger in an accident. I mean, yeah, you can receive the money, but be careful. I did a video about that. You don't want to settle, especially if you're in New York, because what happens is if you settle with one defendant, but then you don't settle with the other defendant, it could be a problem, because then the non-settling defendant can choose either to offset the verdict. If you go to trial, right, they could offset the verdict either by the amount of the settlement, meaning like, let's say you have a case where you're trying to get like $1 million and you have two defendants, like a truck and a car. And let's say you settle with the car for like 100,000, and then you go to trial against the truck, and then the jury says, okay, well, it's 50-50 liability. Well, the truck, the non-settling defendant, can then choose. They could say, if the jury gives like, let's say $1 million, right, against the truck, they could say, well, now we could either reduce by 100,000, and it's the truck's fault. I'm sorry, the truck's choice. It's their choice. They could choose. We're going to reduce by 100,000, so you would get 900,000, right? Because you already got the 100,000. That would be the best choice. But they do what's better for them, or they could choose the percentage, which is what they would choose, right? If it's 50-50, and now you lose 50%. So now instead of getting $1 million, you only get 500,000. So you get 500,000, and you already got the 100,000 or whatever you settled with them before. You see, but it can really hurt you if it's different. What if they say the truck is, 1% at fault, but the car is, 99, and you do that? Then you only get, and it's $1 million. Now you only get 1% of $1 million, right? Which is what, almost nothing, right? I don't know, but it basically, I don't recommend it. It's not good to do that unless your state has different laws. So you'd have to ask your attorney. But in New York, I know it's a general obligations law, and it's not recommended to settle with one defendant and proceed with the other one because of that. And also, you lose the joint and several liability, because when you have joint and several, it means that, like, if there's $1 million, right, even if the truck is 1%, but they have, let's say, 10 million, and the car is 99, but the car has 25,000, and the jury says it's worth $1 million. Well, you could get the full $1 million because you have the 1% against the truck. But if you settled, they could choose. You see what I'm saying? They could choose either whatever's better for them, either the amount of money or the percentage. So if they choose the percentage, you lose all that percentage, and then then you're basically, it's like malpractice. You don't want to do that. I mean, malpractice for the lawyer. Okay, and then JRM says, good evening, great content. You would be a great law professor. Oh, thank you so much. Maybe I have to consider that. And Lasana says, how long do you usually have to wait to get a preliminary conference in the Bronx? I don't think it's too long in the Bronx. I know in Manhattan it's been long. In the Bronx, should be just like maybe a few weeks. It shouldn't be too bad. Maybe a little longer, maybe a month or two, but it hasn't been too bad. I haven't heard anything bad about the Bronx. But the Bronx is slow to get a trial, but the preliminary conference is okay. And then Brandon says, can a settlement in a car accident happen before a deposition in litigation, or so they usually settle after the deposition when it's clear liability on a rear-end accident. So you're asking if a settlement in a car crash can happen before a deposition. Yeah, it can. But they usually do it after, right? Because the deposition is like their chance to chat with you to see what the case is all about. So if they don't even know that, then they're not going to give usually big money unless they like know the lawyer and they're like afraid of the lawyer. Like I had a case, I was talking about it a few weeks ago, where I gave a case to some lawyer that I know is really good lawyers out in like another state, and they already it just happened that these defense lawyers and this lawyer that I gave the case to already had a case, so they already knew each other. So this new case comes in, and it was a serious case, like really, really bad injuries, like life-changing case. And I think they had like a certain amount of money, like $3 million or $4 million. And as soon as they saw like who it was that was coming into the case, they were like, "Oh, it's you guys? Just take all the money, like whatever it was, $3 million from them. Just take it all. We don't want to deal with you." They didn't even have to file a lawsuit. They didn't have to do anything because they're just like have a reputation. But these guys, when they go to court, they hit for like 50 million, 40 million, 30 million. They're like really good. So unless it's that kind of situation, but usually it's after depositions. Okay, and then Moha says, my lawyer said I can dig into my own auto insurance for more money. The accident happened using work vehicle. Yeah, you can go, if usually, I mean, in New York, the way it works is, for example, if you get, you have to have more. So for example, like if a $25,000 policy hits me in the rear, right? And then I get the full 25 from them, but then I have 100, I can get the difference from my own. It's 75 more from my own because I have more. But if I have 25 and they have 25, I can't. That's usually how it works. And then Sandy says, what is an eggshell client? Oh, yeah. I think I've done a bunch of videos about this. So eggshell just means that like you take your plaintiff as you find him or her. So for example, if a client, let's say, is like a bodybuilder, they're super strong and they're, they get hit by a car, if nothing happens to them, maybe they don't even fall down. So the case is like not really worth much. They have a little boo-boo and they might not even sue or whatever. But if you have like an old, like octogenarian, 87-year-old who was like a real, like, let's say their head is like an eggshell. They get hit, they fall over, their head hits the concrete, blood on the brain, hematoma, subdural brain injury, fractured spine, whatever. Major case. The same exact conduct, right, by the defendant, but now it's worth like 10, 20 million, right, because it's so horrific, life-changing. So it's just basically, they call it eggshell plaintiff. They're basically saying that you take your plaintiff as you find it. It's kind of like, you break it, you bought it, right? Like, you don't know, right? I'm in a store, I knock this over, nothing happens to it, right? But if I knock over some kind of vase that's worth like $1 million, I'm like, oh my God, well, you have to, pay for it. So it's just like, kind of, that's what it is. It is what it is kind of thing. Like you take your plaintiff as you find them. And then Shazak says, good evening, how are you? I have an ongoing rear end case. The defendant has accepted liability for $50,000. So what should I expect next? Well, usually they accept liability. If they accepted liability for an amount, you mean like they have $50,000 in insurance and they've accepted liability, or they've offered you $50,000? If they've offered you $50,000 and they have like only $50,000 and not a penny more, and your lawyer says you should take it, then you just do a settlement, you get the money. But yeah, usually they accept liability. Accepting liability is like accepting fault, and how much they have is how much insurance they have. But usually they don't accept fault for an amount. They usually either just accept fault and then you go to damages, or they offer you a settlement, which is a settlement offer. So I'll just double check that. Okay, everyone, thank you so much. This was a good session. We had a lot of good questions. Oh wow, I've been doing this for like an hour, getting a little gotta relax my throat and getting a little scratchy throat. An hour and 20 minutes. That's good. It's good. We got a lot of good questions. Okay, please like and subscribe to our channel. Let us know what questions you have. We are here for you. Our goal is helping serious injury victims and families. And all the best, everyone. All right, have a great night. Bye-bye.